Hey, what's up, guys? This is Adam D'Angeli from the Rescue Michigan Coalition. And in this video, we are going to look at a strange case that happened in Washtenaw County where a judge has legalized protesting in the streets without a permit, blocking traffic. And we're going to use this case. We're going to analyze it, but then we're going to talk about what we can do about it, how you can formulate a legislative project based upon current events on things that are happening in your community. So, on one hand, we're going to be analyzing what happened in this particular instance and talking about where policy has had problems and where courts have intervened and caused problems. And then we're going to talk about how you can organize effectively, how you can create a legislative project where you can go about changing the law. So, what we're talking about here, this is the case. This is from just this past February. A Washtenaw County judge has dismissed charges, civil infractions against demonstrators who occupied the streets of Chelsea, Michigan, in western Washtenaw County. And leave it to the mass media. The headline is misleading. It says, citing First Amendment, judge dismisses charges against anti-racist protesters in Chelsea. And I'm sure these folks view themselves as anti-racist, but that's not the issue here. They're confusing what's going on here because looking at that headline, you're thinking, well, they have a right to protest. What's the problem here? No, the issue is that they were blocking traffic, and apparently there was also some altercations, but you're not supposed to normally be able to just occupy a city street, block traffic, cause people, potentially endangering lives, because you never know what's going to happen when pedestrians suddenly start occupying a roadway. And Michigan, in fact, had a law, still has a law, that says you can't just obstruct a street. But something very strange happened a few years ago. The opinion of the Attorney General of Michigan at the time, Bill Schuette, was that the law against obstructing traffic seemed to have also made it illegal for charitable organizations to solicit contributions from the side of the street. And that's what happened here. So just to give you a brief overview of the story, here's what came out this past February. Impeding traffic charges have been dismissed against several of the protesters who participated in demonstrations last summer in the city of Chelsea. Judge Anna Froschauer declined to, I'm not sure if I'm pronouncing that correctly, Froschauer, declined to charge members of an anti-racist activist group, questionable, but let's just give them that, on impeding traffic violations, ruling that punishing individuals would be in violation of the First Amendment of the United States Constitution. Now, again, this article is completely misleading. That's not what the judge said. Now, what the judge actually said is in itself very interesting. So let's look at what actually happened in that case. This is the transcript of the hearing in which the charges were dismissed. And here's what happened to the court. That refers to the judge. And let's scroll down to where the judge basically says what happened here. So in 2017, the Michigan legislature passed a law with almost unanimous bipartisan support to say that people who were soliciting charitable contributions from the side of the road, like the Lions Club, for example, were not impeding traffic. And what happened was a local municipality, I think it was in Huron County, which is like in the tip of the thumb, had a local ordinance prohibiting the solicitation of funds by the side of the road for charities. And he asked for the opinion, the state senator, Phil Pavlo, it's spelled Pavlov, but I believe it's pronounced Pavlo, asked the Attorney General, Bill Schuette, what his opinion of it was. And actually, this is the opinion. This is it right here. So it's addressed to the Honorable Phil Pavlo, a now retired state senator. And he's asking about, is it legal for a municipality to prohibit soliciting contributions? And so here is what the Attorney General says. And what he basically says is, yeah, if they are impeding traffic, and we don't really have a definition for what impeding traffic really means. We're going by the dictionary definition. So here's what it says right here. The interpretation of statutory language begins with the plain language of the statute. And we don't really have a definition because the Michigan Vehicle Code does not define the terms block, obstruct, impede, or interfere. Those terms will be given their ordinary meaning. And so the Attorney General basically said, yes, it's okay for this municipality to ban charitable organizations from soliciting contributions because that's impeding traffic. So this led to the Michigan legislature in 2017 introducing and passing legislation that created this section of law here, saying that if you are a charitable organization, and there's these restrictions here, you have to have insurance, you have to be 18 or older, you have to wear high visibility apparel, it's not a work zone, and it's also saying up here it's during the daytime, then this does not apply to you. And that's what the Michigan legislature passed. So what the judge argued in this case here, she says that, well, if you can solicit funds by the side of the road to raise money for your organization, that's no different from any other kind of speech. So what she says here, let me pull up the relevant quote here. Let me see if I can find it here. Hold on one second. Here we go. Almost there. Okay, so she's going through. Here's where she's talking about the plain language of the statute. The interpretation of statutory language begins with the plain language of the statute. Same thing we just saw in Bill Shue's opinion. She says the best indicator of the legislature's intent are the words they used. When determining this intent, effect must be given to every word, phrase, and clause in the statute to avoid interpretation that renders nugatory, which means meaningless, or surplusage, which is the opposite kind of meaningless, any part of the statute. So what she argues here is that because they've said that it does not apply to a person who is soliciting contributions on behalf of a charitable or civic organization, that's not fair. Because the First Amendment has to apply equally in terms of the content of your speech, right? So if you have the freedom to stand by the side of the road and ask for money for your charity, you should also have this freedom to stand by the side of the road and scream and yell about what the government's doing. The problem is that it's not what they are doing, what cause they're advocating for, that was the difference. The difference was that a charity does not stand in front of traffic and block them. And you see here that right in the picture, they have blocked off an entire half of the street. And they're also trampling over public property on the easement. And looks like they're also on some people's lawns. But that's what the issue was. But what the judge is saying here is, no, as long as you are allowing people to solicit money for charity, you cannot say that you can't do the exact same thing to protests. And that might be fair as long as the conduct was the same. But let's see what the judge concludes here. The judge says, soliciting for a charity or civic organization doesn't provide a cloak of protection against getting hit by a car impeding traffic, yet this type of speech is exempt. That is an absurd result. But that's how it's written. That's how the legislature intended to be. That's how the legislature intended it to be written, and that is content-based regulation of protected speech with no compelling government interest. I beg to differ, but we'll look at that in a second. But here's what the conclusion of the judge is. This court finds that MCL 257.676B subsection 2 is unconstitutional. That is what the court has concluded. That subsection B, or subsection 2 of 257. So this is what the judge has said is unconstitutional. Now, you might think that doesn't make sense because what the judge has said is unconstitutional is not marching in the streets without a permit. It's that you can't have an exception for a charity. And you're right, the judge got this completely backwards because what the judge said when she says we are Declaring this section unconstitutional is not legalizing protesting in the streets without a permit. It's criminalizing or recriminalizing, I guess, the exception to it, that you can't have this exception. So the judge got that completely wrong, completely backwards, but in practical effect, what's most likely to happen? It's going to be taken as a legalization of impeding traffic for protests. Even though the judge got it completely wrong in how she expressed it, that's what she was getting at was, and it doesn't really make sense, but that's what's happened. The judge has said, okay, the legislature legalized charities eliciting funds by the roadside. But what they didn't do was allow anybody to solicit anything from the roadside. So now we've got a problem here. Problem number one is this judge has now legalized occupying streets without a permit, which is dangerous, which is, I mean, fundamentally, it's almost violent. The notion that, oh, yeah, people can just occupy the streets without a permit, and who cares about the public that might need to use the roads for some reason? So there's that problem. But then on top of that, she appears to have also nullified the law that they passed in 2017, allowing charities to collect donations online. So now the question is, what can people do about this? How do we rectify this failing of the judiciary here? And by the way, this doesn't automatically apply to the entire state of Michigan, but having this precedent being set by the Washtenaw County Court, chances are now any jurisdiction where the judiciary is liberal is going to go ahead and say, yeah, we have now legalized just occupying streets for any political reason. Because that's the way liberal judges operate. They decide what policy they like, and they forge the law around that. So that's just the way that goes. So now you got a problem if you're a citizen in Chelsea. Now the court has just given the left a rubber stamp to go out and demonstrate more and cause more trouble and occupy roads. So now we've got a problem here. We've got a problem with, on one hand, they've also nullified the law allowing people to collect donations for charity, but then also they've legalized impeding traffic. So here's where I think we can take a lesson in this. How can we fix the policy? And there's all kinds of different issues out there, but what I want to do is take this issue and form a model for an effective legislative project, because we've got grassroots organizations all over Michigan that want to do one thing or another on a lot of different topics, and people who don't know how to engage the legislature and write policy and form a plan for effective legislative action can see this through. So let's go through this. We've just spent a lot of time belaboring the failing of the policy and the failing of the law and what the judge did. So now the question is, what can we do about it? So one potential possibility is litigation, and they could appeal this, but are they likely to? Probably not. It was over some civil infractions. The city of Chelsea probably doesn't have the resources, probably has no interest in appealing this. So while there might be a judicial remedy for figuring out how to correct what the judge got wrong, it doesn't often happen. It's not likely. But the judge has said that this section of law is unconstitutional. So the question is, how can we fix that? So the first thing is you have to go through all of the details of what went wrong and figure out how to make it right. That's what we did in Rescue Michigan with the election laws. Look at what went wrong, what were the failings in the system in the election in 2020, and what can we do policy-wise to change it? And what can we do through the legislature to change it? So a judge has now said that this section of law, this subsection, paragraph 2, is unconstitutional. So the first thing is, if we have a legislative remedy, it's going to be to fix it right here. So what's wrong with this? Well, the first thing is we want to probably address what the judge actually said, that the small element of what the judge said that has value, which is that, yes, if you're allowing someone in a charity organization to solicit funds by the roadside, you probably also have to allow everybody else to do the same thing. And that's probably fair. And what this shows us is that maybe the way that this law was developed in 2017 was going after the wrong problem. The problem wasn't that a charity organization was excluded from being able to do this. The problem was there was no consistent understanding of what obstructing traffic actually means. Going back to the Schuette opinion, he says, the Michigan Vehicle Code does not define the terms block, obstruct, impede, or interfere. These terms may be given the ordinary meaning, so they're going to the dictionary, which is, the dictionary is not a good backstop for what a legal definition really is. I mean, and in here we have it right here. He says, obstruction and impeding are incorporated into the definition to mean anything that stops movement or progress, any obstruction, obstacle, or hindrance. And that's how the Attorney General got to the opinion that soliciting funds for charity could be considered to be impeding traffic. So that's where we can make a correction. And I'm going through all the details of this because it's important. If you're crafting legislation on whatever your local issue is, maybe it's something like this, but it might be something completely different. You really have to think out, and it might be good to talk to an attorney about this, looking at what the failings are in the policy and how they can be corrected. So here's the issue. Remember, we're distinguishing between people kindly, generously from the side of the street saying, hey, buddy, can you spare a dime or a dollar or two for the Lions Club or for the American Legion or whatever it is, versus a mob of people occupying the street without a permit, intentionally and deliberately hampering traffic and causing danger. And by the way, folks, this can mean real danger. Just to show you, this is, here's a video of what was going on in LA around the time of, I think it was the Oscars. It's just a couple weeks ago. This is what in-road occupations can do. I just realized the sound was off. All right, but you get the idea. You see what I'm talking about. This is what happens when people decide they can take the law into their own hands and whose streets? Our streets. Well, no, they're not your streets. They're the public streets. And when you occupy the streets, you're infringing upon everybody else's right to use the streets. And you might be putting lives in danger doing that. That's the policy that has to be fixed. So, you want to introduce a legislative fix. So the first thing is coming up with what the policy change should be. And you want to do the best job you can with this. I'll show you what I came up with. This is section 676B. And what I've done is I've basically mirrored what a legislative office would do when they introduce legislation, which is you take the existing law that you're amending and you cross off what you want to remove and put in boldface what you're adding in so that they can see what exactly is being changed here. So all this is the existing law subject to subsection 2. A person without authority shall not block, obstruct, impede, or otherwise interfere with the normal flow of vehicular or pedestrian traffic upon a public street or highway in the state by means of a barricade, object, or device, or with his or her person. And it's obviously what they mean by those things. But they added subsection 2 to make clear that they were exempting charities from this. But again, the judge actually, in a small way, was right about the fact that you shouldn't be able to discriminate by speech. And again, it's not what they're doing, it's how they're doing it. If you want to stand by the side of the road to protest, no matter who you are, that should be fine. The issue is when you get into the street and occupy it for an extended period. So we come up with this sample language here. So we're taking out to a person who is soliciting contributions on behalf of a charitable or civic organization during daylight hours, because we want to make clear that's not what should be restrained. So here again, we take out in subparagraph A, the charitable or civic organization, no, just a person complying with applicable local government regulations. And here, where originally it said the charitable or civic organization maintains at least $500,000 in liability insurance. Well, that's fair, right? If you're going to be in the street, you should have to have insurance. So the person or organization on behalf of whom the person is acting maintains at least $500,000 in liability insurance. And again, you see, here's where the judge really screwed this thing up, because the demonstrators weren't wearing high visibility safety apparel. They didn't have insurance. They just took it upon themselves to jump into the street because they felt they had the right to. And we added in that this applies in daytime because we took that out over here. So now in paragraph 3, we say a local government or authority's jurisdiction of roadway, and we took out upon which solicitation occurs because we're not restricting it to that. And now we create the clear definition of what you can't do. So subject to subsection 5, a person who violates this section is responsible for a civil infraction. Okay, so we've expanded the definition of what you can do to anybody who is complying with all of these terms. But here is the other thing. If we're going to change the law, we should point out, I've mentioned it already, but we should point out that a mob of people obstructing the street is not okay at all. No. Maybe it shouldn't just be a civil infraction. In fact, maybe because a judge has eviscerated this law in service of BLM, we should do one back and point and say a person who willfully obstructs, impedes, or otherwise interferes with the normal flow of vehicular traffic or pedestrian traffic is guilty of a misdemeanor, a criminal charge, a minor one, but still a criminal charge. I don't think that's unreasonable. Now, when this goes somewhere, if it goes somewhere, the legislature might. Maybe they'll knock it down. But that's the normal legislative process. But ask high. You know, you're asking the legislature to change state policy. So ask high. Ask for a misdemeanor. Maybe even ask for a felony. I don't know. But that might be a bridge too far. But define what exactly it is we're talking about. So we remove this definition of charitable or civic organization because, as the judge fairly pointed out, that shouldn't be the issue. It's not the content of what you do. Well, it's not the content of what you're doing it for. It's what you're actually doing. It's willfully obstructing traffic. So we add this definition here because this is where the Attorney General said we don't have a definition. So let's be clear. As used in this section, willfully blocks, obstructs, impedes, or otherwise interferes with the normal flow of vehicular pedestrian traffic means to knowingly and intentionally create an obstruction to traffic such that a motorist or pedestrian is compelled to stop or change course to avoid the obstruction, and such obstruction is maintained for a period of 5 minutes or more. So, first of all, where'd all that language come from? I made it up. Is it the best language? I don't know. Why'd I say 5 minutes or more? Well, the reason is I'm thinking out how could this be misapplied? That's what we're trying to prevent, right? So what you don't want to have happen, and this is what the Attorney General in his opinion years ago was trying to get around, is, you know, the issue that we had is if you solicit funds at the side of the road, someone pulls over to give you money, you're blocking traffic, right? I mean, only for a couple of seconds, probably, right? But that could be considered an obstruction, and that's why it was problematic. So I say 5 minutes or more because that's not plausibly how long it would take for anybody to pull over and give a guy, a bill or a check or what have you. Is that the right thing? I don't know, but it's at least a starting point. And if a bill is going to go through the legislature, it's going to be considered by the committee. It's going to be considered by the other chamber. It's going to be considered on the House floor. There's going to be stakeholders that have input in this. So it's going to come around. But at least we have sample language. And that's an important starting point, because when you approach the legislature and say, we need a law changed, you want to do all the homework for them. You want to say, here's exactly what we want, give or take a little bit. And they'll get pushback. They'll talk to stakeholders. That'll happen in the process. If it doesn't even happen in drafting, it'll happen when it goes to the committee. In fact, what you can do is go back to the stakeholders when this 2017 law was passed and talk to them about this. Here's where you can find the testimony from when this law was passed in 2017. What I did was I went back and I saw that it was a 2017 law, and it saw in the records it was passed by the Transportation Committee, the committee that it came through. So I looked at their records, and you can find them here. It all happened in late April 2017. There's the bill. There's the testimony from different stakeholders in the bill, and you can pull them up. So here's a testimony from the American Legion, and here's what they're explaining is why they supported that bill that this Washtenaw County judge struck down. And they say, we're raising a lot of money by roadside fundraising. And by the way, I'm not doxing the guy. This is in the public record in the committee testimony. This is the guy who testified in support of the bill in 2017 that the Washtenaw County judge struck down. And there's others. Here's the Lions Club of Michigan. We raise $1 million a year through our roadway fundraising efforts. They really are good for us. This is why we support them. This is how you can build a coalition of people that are going to support your issue. You can call the guy up. Hey, Justin, did you know that a Washtenaw County court just struck down the law that allows you guys to fundraise at the roadways? His information's right there. Call them up. Get feedback. You can vet the language that you came up with through them. And they might say, you know what? You're right. It's a lot smarter to tackle this issue in terms of the behavior of what defines an obstruction versus saying that we're making an exemption for charity-based organizations, right? So now the next thing is how you're going to pitch this to lawmakers. And what I have here is a mostly redacted policy office memo, and this one is from the Michigan House Republican Policy Office, but every policy office for both parties in every state legislature and Congress have memos like these. These are what they give lawmakers when they're considering legislation that's coming to the floor. And for members who are not on the committees where the bill came through, for most of them, this is the first time they've heard about this bill and what it does. So again, I've redacted most of this. The parts I haven't redacted don't need to be redacted because they're just public record. House Bill 5420, House Bill 5421. This is in the 2018 legislature. So you can see I've blurted out who the advisor was. It went to the Tax Policy Committee. And the reason why I'm showing you guys this is because this is the kind of thing that here's again where you can help lawmakers by doing their homework for them. This is the things that they're looking for. They want to understand, and they want an easy to read memo that shows you what the bill does, what the issue is, and where the stakeholders are. So let's go through this memo here. So first they call it an executive summary, not really executive, but it's a summary. It just says, here's what this bill does. And again, I didn't redact this because it's straightforward. It amends the Income Tax Act to update with respect to what changed in federal law. There was the Trump tax cuts, and now suddenly, if we don't change the law, Michigan citizens are going to lose out on tax exemptions they could get. So they very briefly describe what the bills do. And then they have a section of articles in support and articles in opposition. They're going to say, here's what people support the bill would say. Here's what people opposed to the bill would say. And these are essentially their talking points on one side and opposition talking points to be aware of on the other. And again, these I did redact because, it is a part of the policy office. It was confidential. So, and this is old stuff. This is from 2018. So it's not important, but I redacted it anyway. And then they give them this background. Here's what the issue is. And this is often not included in bills. Usually just goes to this. There's an issue problem section. And here's where they explain this is why we need this. And again, this is the plain English stuff that lawmakers need and which everyone really needs to understand what a bill is and what it does. And it's important if you're going to take a proposed legislation to a lawmaker to introduce that you can show them, here, this is exactly how you sell this. Here's what the issue is. Here's what the policy is. Here's why that works, et cetera, et cetera. Here's what pitfalls to be aware of with respect to arguments in opposition. That's why they included that up here. So that's what they're doing, is they're giving lawmakers essentially the gist of it. So then you have bill content. And again, I did not redact this because it's also self-evident from the bill, but they're basically just saying, here's what this bill is doing. And then the fiscal impact, this comes directly from the House Fiscal Agency. And it's just saying that if we don't pass these tax cuts, people won't get their tax cuts and we'll get more money, but the taxpayers won't. Oh, gotta restart, gotta say no to that. And then and this you won't have in your memo, but you might put in who you think would support this, who you think would oppose it. And in this case, this is all, I mean, I partly redacted it. You can see some of who was in support and opposition and neutral, but that's okay because it's also a matter of record. This is just coming directly from the Senate test or from the committee testimony. And then there's the committee vote, and it shows how members of the committee that the bill was assigned to voted. And they're off by one here because it was 12-0 to 1, not 12-0-2, but they show you who voted yes and who voted no and who voted pass in the committee. Procedural notes, not important. You don't have to worry about that. In this case, it's just saying effective date, they're requesting immediate effect, which minor technicality does not matter. But the point is, what you want to do is to write a memo like this for who you want to approach to be your sponsor so that they can feel comfortable that they know what it is that they're going to be doing. So here's what I'd propose. You want to write something like this, where you lay out what it is for the lawmakers that you want to do and why they should support it. So here we have essentially exactly what we've been talking about written in one page. Legislative project, clarify. Lawful roadside fundraising versus illegal roadblock protests. Summary. In February 2021, a Washtenaw County judge ruled that MCL 257.676B subsection 2 was an unconstitutional violation of free speech. This is really important, folks. You're showing them exactly where the problem is, what the problem is, that there is a problem. This law was passed in 2017 to clarify that Michigan's prohibition on impeding traffic did not apply to insured organizations fundraising for charity. The previous year, the city of Chelsea ticketed demonstrators for illegally filling the streets and blocking traffic, having done so without a permit. Notice we have control over how we're pitching this here, so we choose a language that we like. According to the judge, the statute constituted a content-based regulation of speech. If one can obstruct traffic to fundraise for charity by soliciting contributions by the roadside, then one can obstruct traffic by filling the street with demonstrators. Obviously, we're implying the judge is an idiot, but you get the point. However, rather than strike, and we underscore it here, rather than strike down the statute prohibiting impeding traffic, the judge struck down the subsection that made an exception for fundraising charities. Now, this is an important little detail because we're attacking something that the judge, I think, didn't actually mean to do. What the judge wanted to do was say, if it's okay to solicit money at the side of the road, it's okay to demonstrate in the speech in the street and occupy the intersections and disrupt traffic. But what the judge actually did by saying that MCL 257.676B subparagraph 2 is unconstitutional, what the judge actually said was, no, the exception was unconstitutional. Which is important because that actually, by her error, attacks the charities. So that gives you an in, and it also gives the lawmakers in to point out what the judge actually did, inadvertently or not, was to attack the charities. The things that all of you, our colleagues, most of them, this was passed 4 years ago, a lot of them are still in the legislature, voted for. So, content of the bill. And again, we're making it simple here. We propose legislation to amend MCL 257.676B2. And then there's bullets. Remove the limitation on the charity exception to roadside solicitation, applying only to charitable organizations, allowing all persons and organizations to solicit drivers during the daytime as long as they comply with local regulations, have liability insurance, are 18 years or older, wear high visibility safety apparel, and are not in a work zone. Clarify the definition of obstructing, blocking, and impeding traffic to delineate between roadside solicitation and in-road occupation, and make willful impeding of traffic a misdemeanor. The proposed text of the bill is included as an attachment. Arguments in support. And again, this is where you get to lay out the best arguments in your terms. 1. A Michigan court has invalidated Act 112 of 2017, which passed 36-0 in the Senate and 97-9 in the House, asserting that it constituted free speech discrimination. While we vehemently disagree that roadside fundraising is in any way comparable to completely blocking traffic by occupying the street, it is correct that those soliciting contributions at the roadside should be subject to the same terms as those making any other speech at the roadside. So we're conceding this is not a speech issue, and this is how we fix the law. The judge said that there was a speech issue here. Let's fix the speech issue. It's not about speech. It's about behavior. You just can't jump in the street and stay there without a permit. The court that invalidated Act 112 of 2017 inadvertently banned charitable fundraising along roads rather than legalizing occupying streets. But in either case, the decision was backward. Charitable fundraising should be protected. Occupying streets without a permit should be illegal. And that's your talking point right there. And number 3, a civil infraction is an insufficient penalty to deter protesters, should be an S there, from illegally occupying streets, endangering lives, and harassing drivers. So there you go. You give that to a lawmaker and say, hey, this is what we want you to do. Here's the one pager. You make it simple for them. This is what's going to become it's called a Dear Colleague letter. When they introduce legislation, they ask for co-sponsors. They send an email to their colleagues and say, Dear colleague, here's the issue. Please sponsor my bill. Co-sponsor my bill. You've written the talking points for them. So that's what you do. You make a one-pager on your bill. Now, next question is, who should your bill sponsor be? Well, typically, the best sponsor is going to be the one that has constituents that are concerned about it. In Chelsea, which is western Washtenaw County, you have a Democrat member in the House, and therefore we can assume is useless. And the Republican in the Senate is Lana Tice, who's actually great and genuinely conservative and genuinely someone that might be interested in taking this up. Because not every Republican is. Sometimes they're more interested in lobbyist stuff and not so much in constituent stuff. Lana Tice is someone's going to look at this and think, yeah, this is a great issue because look at this. Number one, this issue shows how the justice system is being abused. It shows how it casts the left in a bad light, that they're claiming they have the right to occupy streets and disrupt traffic and endanger lives. This is the kind of bill that just by making the fight, we're going to be able to improve our political advantage because we're shining a spotlight on the very bad things that the left does. Namely, invasive, nasty, and violent protests. And by the way, there was apparently some kind of incident at this demonstration. It was not entirely peaceful. It was mostly peaceful, I guess, but apparently a BLM member has claimed that she was punched in the mouth by a counter protester. I'm sure that's the whole story. Because that's how that happens. You just peacefully demonstrate in the street and someone just comes up and socks you in the mouth. She did file a police report. So it's not entirely made up, but there hasn't been any follow-up on that. So who knows? The facts are complicated. Point is, demonstrating in the street, not a good thing. And maybe the local state representative or senator, in this case senator, might be the best person to introduce this. But what if your state representative and senator are Democrats? Well, then you've got to find the right person to be the sponsor. So where do you go? Well, let's look at maybe some possibilities here. So we're going to look at here. Well, the first question is, what committee is it going to go to? Well, we can tell because the bill the law that the judge ruled unconstitutional went through the Transportation Committee in the House and the Senate. So first thing is there a member in the Transportation Committee in the House and Senate who might be a good representative or senator to be the one to be the bill sponsor? And within those, questions are, is your sponsor going to be committed to your issue? Are they going to be focused on your issue? And it's going to, in this case, because this is clearly a partisan political issue. Not that it shouldn't be. Demonstrations that are violent, demonstrations that endanger lives should be illegal, should be a nonpartisan issue, but, doesn't always work that way, unfortunately. Yeah, immigration shouldn't be a partisan issue, election reform shouldn't be a partisan issue, it just somehow shakes out that way sometimes. So, you look at the members of the State House Transportation Committee, and you got, because I know them, I can see a few that stand out. Gary Eisen, Bo LaFave, Steve Cara, people who might be very likely good sponsors. But I'm also going to look at the Senate Committee. In the Senate Committee, we've got Tom Barrett as chair. Tom Barrett's a good conservative. You got Ed McBroom there. Rick Outman's pretty good too. Might be better to come through the Senate, because one of the things, and here's where it's important to know the details of the process. One of the things that happens is in the House and the Senate, they have different rules, they have different procedures. In the House, a bill doesn't always just go through one committee. In fact, they usually don't. Usually they'll go through either the Ways and Means Committee in the second committee or the Judiciary Committee. In fact, the rule is if a bill creates a new crime, as ours does, it goes to the Judiciary Committee secondly. And that's a different committee. You've got Graham Filler as chair, Mike Mueller, Steve Johnson, Brian Akali. Darren's good. Brian Berman's pretty good. But you have complexity in the House that you don't have in the Senate. It might be a smarter play. And again, because the local senator is a good conservative, Lana Tice, it's looking like maybe that's the better route. But try everything. Try everything. Try reaching out to the members in the House committee, in the Senate committee, see where you get. See where you get and see where things go. So we've gone pretty long right now. I'm going to kind of wrap it up here. There's a lot more to talk about, how to shepherd a bill through the legislature, but we've talked about how to develop a policy. We've talked about how to sell the policy, how to write a memo for it, how to look for who the best sponsors are. So we've covered a lot of ground here. So I hope this video has been helpful. By all means, feel free to leave a comment, ask questions, and we can follow up. But on one hand, this is a real life example, but it's also an illustration. It's how you can look at a current event, identify what the failure is in the policy, and how to formulate a plan for carrying that forward. So I hope this has been useful to you guys. Again, if you like this kind of content, I don't know anybody else on YouTube who's talking about the practical aspects of legislative procedure and grassroots organizing. So please, if you like this kind of content, subscribe, leave a comment, share this with other people. And until next time, this is Adam D'Angeli from the Rescue Michigan Coalition signing off. Thanks everybody for all that you do for liberty.